Alrighty, this will be the People News. One more time at it. Educational purposes only. Not attorney, not giving legal advice. Alright? Never look straight forward, always look around you, be able to protect yourself by any means necessary. Use that Second Amendment, arm yourself with knowledge. Alright, so I know we've been missed a day or two, I can't remember now, been busy. So just a little bit more idea of what's going on here. There's a lawsuit about suing magistrates because Randy Kelton is really famous of filing a criminal complaint on like officers, other judges, other magistrates. He's all out there doing these things and filing criminal complaints. And what the problem here in Texas is, and as well as most states, is that they have a tendency to ignore everything. Well, he decided what he's going to do now is actually throw a lawsuit against the magistrate for not doing their job. Okay? Or the clerk of the courts not doing their job. And so, I mean, we got to start from somewhere. And for people in Texas, write these codes down. Study them. All right? Because this is where you can get the information. Obviously, whatever the cops do, if they call it battery, then you want to look on, the Texas Code of Battery, and you file that criminal complaint with the magistrate and issue a warrant for that officer. But you're also allowed to do that with also Criminal Code 39. Okay? And the 39 section is actually designed for the government people here in Texas. Sorry. That was my AC. I had to shut it off. But that's what it is. I don't know about any other states if they have a particular code to actually file a criminal complaint against any of the government body, but Texas does. Valley, there's some form of remedy in Texas. After all, they've been breaking every single freaking law there is. And then they call it law. All right? Violating the Constitution, state and federal. Due process. Texas is literally a police state. All right, let's proceed forward.
Properly written. See, defendant's actions suggest that defendant's intentions were to shield the persons named in the complaint. Named in the complaints filed by plaintiff from prosecution in direct violation of Texas Penal Code 38.05 Super. Duty to know the law. It must be construed that defendant acted with full knowledge of the impropriety of his acts as construed by the United States Supreme Court in Screws et al. Okay, which reads in pertinent part, and again, if he's not insane, he must be declared to know he knows what he did. Okay, when culpability. When defendant failed to perform the above referenced ministerial duty defendant was commanded to perform, defendant was criminally culpable. Again, Randy, stop fucking trying to explain these words to judges. Are you nuts?
Right? You don't want to explain all these things to them. However, I can see Randy's point of really getting it clear so you don't have to keep fighting this, right? They're going to go in there and go, ooh, E-I-O. We may settle this matter. We better settle this matter, pretty quickly, especially if it's been explained. Just saying. I don't know. Negative plus, you guys decide on that. That was just an option there.
As construed by the Texas legislature on passage of Texas Penal Code 6.01, which reads as follows. Requirement of voluntary act or omission. A person commits an offense only if he voluntarily engages in conduct, including an act, an omission, or possession. Possession is a voluntary act if the possessor knowingly obtains or receives the thing possessed or is aware of his control of the thing for sufficient time to permit him to terminate his control. C. A person who omits to perform an act does not commit an offense unless the law is defined by section 1.07 provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Okay. In reference to section 6.01c above, the actions complained of herein were specifically mandated duties of the public officials involved. Okay. No discretion. When a complaint is presented to a magistrate, the magistrate is commanded by Texas Code of Procedure 15.09, which again we've already seen. You will notice that the legislature was clear in their mandate to issue a warrant. The legislature used the term shall. In law, shall does not mean may, might, or can if she wants to. It is obligatory. It means must and must be construed as such in accordance with Texas Government Code 311.016, which reads as follows. Following constructs apply. May creates discretionary authority, shall imposes a duty. Under the provision of Texas Code of Criminal Procedure 15.09 super, legislators intended that there be no official gatekeeper. When a complaint is presented to a magistrate, said magistrate is commanded to issue a warrant as shown above. Nothing in the letter of the law can be construed to give the magistrate discretion. Public officials, by abuse of their discretion, have slammed the door shut to the public they serve.
In short, right there, right? Nowhere in the law says that you can ignore the us filing a criminal complaint against an officer, right? So in Texas, there's no law saying there is qualified immunity, and there is no law saying there ain't qualified immunity. So they just go by assuming, since federal court has it, that Texas is just going to ride their coattails. But the qualified immunity, if it does exist, doesn't exist until you get into federal court, because Texas don't have it. And then you got to still challenge that. If it's not the law, then it's in the powers of the people. The courts must make a ruling on the people's behalf, which they do not do. Again, violation of their oath, violation of their trust, unclean hands, dishonor, throw the robe away.
As a direct result of the above, our system is horribly out of control because the servants have locked out the masters. The fiduciary duty. In Texas, before a public official can take office, the people demand that they swear on their oath to their fidelity to the Republic of Texas and the United States. Oath of office. In Texas, an oath of office is a solemn promise or affirmation made by an elected or appointed official to faithfully discharge their duties and responsibilities. While an oath of office is not a traditional contract in the classical sense, it shares similarities with contractual obligations and can be viewed as a binding agreement between the official and the state. Here's how. Well, here's the thing. Randy has just said between the official and the state. Okay? Well, unless they're going to find that the state means the people, they ain't talking about us, is it?
No.
So therein lies the problem. What definition of state are we going to be using in this? Remember what the definition of state is in Chapter 311 of the Government Code?
Is it like state, the United States, which would be BC and surrounding territories?
Nope.
Or is it
The
just
federal
this
office.
state?
The definition of state under Chapter 311 is a federal office.
It's just our state office or federal?
No, a
office.
federal office. Federal office.
So it creates ambiguity?
Ambiguity? What's ambiguous about a federal office versus the state of Texas? They're not the
Well,
same thing, are they?
Yeah, they're not, because federal would be to the United States itself and not the state itself, right?
I'm not sure what you're trying to argue about that, but try again. Texas Government Code, Chapter 311. Saying state, but we don't know what the fuck he means by state. He doesn't know what the fuck he means by state, and that creates a problem. All right, look right here, number 7.
All right, so this is part of the points we need to get to, right? We got to read it and just tear it apart, okay? And break it down, okay? This is one of the things that could be statutory construction or investigation, uh, either or, but you go in and you break these words down and then you find the definition like the state, where then you want to make something showing the state because it's whatever they mean, but you didn't know it. So therefore, you agreed to their terms and you don't even know what you agreed to. Right? Just saying. We talked about person all the time. Well, when they put person in there, which definition are they using? You got to look up the person in that statute or in that Texas code or your codes in your state. You got to look that up and find out what the person means in this section, blank, 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 blank. 99% of the time, it's individual, person, business, trust, commerce, and maybe a couple other things, but it all has to apply with businesses. Well, then how does that apply to you? And this, people, is what attorneys are ignoring. And this is what pro se's are using, because they go in there and they break it down and not just read it and just go along with it. Some do. But that's what you got to do to win and box them in.
State, when referring to a part of the United States, includes any state, district, commonwealth, territory, and insular possession of the United States and any area subject to the legislative authority of the United States of America. Then you look down here at what the definition of United States is, and United States includes a department, bureau, or other agency of the United States of America. So, if state is being referred to as part of the United States, then this is the definition of United States, all of which are federal offices. Therefore, state can only imply a federal office. See the problem?
Yes.
What else is it going to be? If there's not a local definition for the term state, this is the one that applies. You know how we know that? The following definitions apply unless the statute or context in which the word or phrase is used requires a different definition. Now,
boom, right there. This is what I've been talking about. You got to go back and see if the statute changes its contents, the definition. Right? The person still could be you if the definition they come up with follows it. These attorneys stay up all night, coming up with crap like this to trick you. This is the reason why it's called legalese, a different language.
Is the catch-22 with this phraseology up here. These definitions apply unless the statute or context in which the word or phrase is used requires a different definition. Well, where do we get the definition to apply it if the context requires it to be different than what it actually says here? What definition do we use then?
What's in the statute, correct?
If there is one,
then this would be
then
the
we
only
fall
one
back
that
on the
applies.
common understanding of the term. Okay.
It's as clear as mud.
Well, no, it's crystal clear that this is all federal. State, everywhere states used is federal, and everywhere United States used is federal, unless there's a local definition that says something different. Now, if you want to say the context requires it to have a different meaning than this, then where are you getting the meaning? Are you making it up yourself? If you're free to use yours, why am I not free to use mine? What makes yours the right definition and mine the wrong definition? See, what this phrasing up here does is it makes everything about these definitions vague, ambiguous, and overbroad. Right off the bat. Because now the meaning of the word is strictly context-based. Which means it can be interpreted depending upon how people wish to interpret the context. You see the problem?
Yeah, Eddie, I have a question.
And this is what we talked about before, right? many videos back, right? Is it Title 1, Section 1 of the USC Code, all right? It tells you in there they're going to trick you. Up means down, down means up. West means east, east means west. But that's what the judges do. That's the reason why they ask you questions. Because they know what the definition they are using. But you're going to the terms of your definition. 100 years in prison. You just sentenced yourself. You just convicted yourself. Alright? The judges say, well, it's 3 o'clock at 3 o'clock in the afternoon. What color was the sky? Well, the judge may be thinking midnight. And you say, well, it's a blue sky. Well, the judge may be colorblind. So it says pink sky. So therefore, you just convicted yourself. You have no idea what the judge is thinking, right? Or at 3 o'clock, well, was that a.m. or was that p.m.? Right? Was it a cloudy day? Was it raining? Was it snowing? Right? These are the little questions they ask, and you bring in, oh, the sky's blue. Well, the sky's not always blue. In fact, even at nighttime, the sky's not always black. It's gray. You got little flickers of lights everywhere. You got the moonlight that comes through. You know? So these things that the judges do to us, they wake up, they stay up all night thinking of things, how they can trap you, imprisonment you.
An issue here about...
I rambled on that we didn't get too far on that. Apologies. But these things need to be told. Because we walk in there and we read something and we just automatically assume. Well, that's what courts do. They assume. Alright? That being said, I should have had that down like that where you guys can read all these other sections. Because all this is very important. And you really, and he will say it, you really know Section 311 and 312 in Texas. Your state, you need to check it out and be able to read these things. That way it's clearly established, right? See, property means real or personal property. Well, that's not true. But in this state, that's what they did. Why? Because they want to restrict your freedom. Just saying. Our Declaration says property. It does not say personal. Or it does not say real. It says property. Because property is a numerous. Personal is not a numerous. Personal property is not a numerous. Real property is commercial. All right. This is We the People News. Bye, y'all.